Much for joining us. My name's Nicola and I work on the AsIAM's community support team. First, I want to say a big thank you to SuperValu for kindly supporting this webinar this evening. Tonight's webinar is part of an AsIAM SuperValu webinar series that we've been running in partnership with SuperValu throughout 2020. So the topic that we will be covering tonight is autism and the law, and there's just going to be a focus on a child's rights and entitlements. So we are joined by Gareth Noble from KOD Lyons, who's a leading lawyer in the area of children with disabilities. And our second speaker is Julie Ahern from the Children's Rights Alliance. Julie is the Law and Policy Manager at the Children's Rights Alliance, and she'll be speaking about their organisation and what they do. Thank you both for giving up your time and offering us your expertise on this matter. So I'm just going to give you a brief overview of how things are going to run this evening. So the first 30 minutes, Gareth will be speaking, and then for the next 20 minutes, we'll be hearing from Julie. And then we'll have a limited amount of time at the end, maybe about 10 or 15 minutes for questions and answers. So if you look at the bottom of your screen there and hover your mouse over it, you'll see a Q&A box. So if you have any questions throughout the presentation, please just pop your question into the box. All of our panelists will be able to view them in real time. So our speakers might answer some questions throughout the presentation, and some other ones we might flag and answer at the end of the presentation, if that's okay. We also ask that you don't put questions into the chat box, just so we can retain confidentiality and keep all questions anonymous. So we also ask that you refrain from including any personal questions, such as a child's name or like including any details like organizations. So if we don't get to your question, hopefully it will be covered in the webinar. And if not, please just get in touch with AsIAM and we'll be able to provide further information. Just a reminder as well to everyone that this webinar will be recorded and it will be available on our YouTube channel from tomorrow. So I'm going to stop blabbing on now and I'm going to hand you over to our first speaker, Gareth. Gareth, I know you don't have any slides, but if you just want to start chatting away there.
It's I'm one of these people that find it very difficult to multitask, so I'm just going to rely on the speaking rather than on the slides.
Brilliant.
Can I first of all thank AsIAM and the Children's Rights Alliance, who are both probably the leading advocacy organisations in this country at the moment, in terms of providing platforms for children. And for their families and their carers. And I know that I've worked separately with both organisations across a range of topics. And so it feels good to be among friends tonight in that context. It's very odd. The last time I spoke actually was with Adam Harris at a public event back in late February, early March in a school hall in a community centre in Crumlin. And little did we know that within a week or two, we would be hearing about things like Zoom and other various platforms. And whilst an awful lot has changed since March of 2020, sadly, for those of us who are in this area, there are many all too familiar scenarios as well. And in fact, in some ways, that has been accentuated by the pandemic, because I think for parents and for carers and for advocates, we always have found it challenging to get over bureaucratic blockages. We've always found it difficult to secure in a timely manner, in a way that is child friendly, in a way that puts the paramount considerations of the welfare of that child at the heart of all decision making. Those have always been challenges for us, and by goodness have they been added challenges to us in light of the pandemic. It was always said at the start of COVID-19 that the hard bit would be, the easy bit would be actually putting in place the restrictions and the supports, and that the hardest bit would actually be coming out of COVID-19 and putting and getting life back together again. And none more so than for children with additional needs who have found it and their families incredibly difficult in relation to the lack of structure and routine, access to assessments and services, all matters that were always issues of concern. But even as we come out of COVID-19, we're still left with the problems around the lack of appropriate school placements, around the lack of school supports, about ensuring that children access assessments and services in a timely manner, in relation to concerns around the manner in which domiciliary care allowance applications, carers allowance applications, and so on are dealt with. It's in that context that the role of advocacy has never been more important. Tonight, I've been asked to speak just in relation to a number of topics. I'm going to look at the whole issue of schools and reduced school timetables, for example, as an issue of concern that I know AsIAm have encountered, as have I. I want to look at the assessment of need process under the Disability Act, and this whole issue of the right to school place and resources. And then hopefully I will conclude by offering some practical suggestions in terms of do's and don'ts, in terms of how we as advocates and as parents and as carers engage with state bodies, engage with schools, and engage with all of those professionals whose input is not just only welcome, but is necessary in order to make children's lives better. I might start, if I don't mind, with the assessment of need process. The Disability Act of 2005 underpins that assessment of need process. And certainly an awful lot of people have been coming to me in the last number of months pointing out the fact that the very scarce resources that were being made available in terms of psychology, speech and language therapy, occupational therapy, mental health services, all of those really, really much valued professional inputs have themselves and those disciplines been impacted by COVID because of the fact that a number of those frontline services for children have been rediverted in effect to fighting the pandemic in terms of contact tracing and other objectives. And so therefore, when we had a very shrunken system, it has, the window has even narrowed more. And I think for children with additional needs, the end of COVID-19 will impact greater on them than perhaps an awful lot of other sectors of our society. And it is imperative, therefore, that we as advocates do our best to impress upon government and others the importance of ensuring that those frontline workers come back to those frontline services before we even go on to start about increasing capacity in terms of those frontline professionals who do such wonderful work for children. I know that those representative bodies themselves, because I speak to many of them, I also find it difficult, and I find it challenging to be able to access children, to be able to do assessments, and to be able to do what's probably most significant of all, and that is to provide the blocks of therapy that are needed thereafter. Can I say, however, that the Disability Act of 2005 is a very progressive piece of legislation, and one of the most progressive parts of it is the fact that under that particular act, assessments of need must be commenced within 3 months, and they must be finalised no later than 3 months from the date of its commencement. Even before COVID-19, in huge parts of Ireland, those assessments were not commenced and completed within the timeframes permitted by law. And it's also really, really important for all advocates and parents to know and to understand that this act itself goes on to say that the HSE is not absolved from its duty in terms of commencing and completing those assessments as a result of a lack of resources. So the HSE cannot use as a lawful defence the fact that they don't have resources in order to commence and complete these assessments. And that's a really, really important legal right for children and a legal right for their families. It's also important to bear in mind that my experience in relation to HSE complaints in recent times is again the use of the lack of resources as the way of trying to avoid that statutory obligation. No Oireachtas, no government minister, no cabinet decision that has ever, no announcement has ever come from government since March to indicate that the timelines permitted by law can somehow be avoided. That contrasts sharply with the position in the United Kingdom, where in the UK, Westminster legislation was actually passed in order to give wider latitude to the commencement and completion and service provision. That wasn't done in this jurisdiction, and therefore it is unlawful for the HSE not to complete the assessments in that timeline permitted by law. And that's a really, really important matter that will no doubt continue to play out as we move forward. It's also very important to point out that earlier this year, before the pandemic, the HSE developed a new operating procedure whereby they would in effect triage what type of assessments might be needed. And for example, if a child needed to be assessed for a possible diagnosis of autism, for example, the position now under the new standard operating procedure is that in fact that might not form part of the assessment, but form part of the services itself. That is legally problematic, and in effect is going to lead to a lot of increased litigation, because the purpose of the Disability Act of 2005 is to determine whether a child has a diagnosis or a disability and the extent of that diagnosis and disability. And if we are now saying that in fact we are not going to determine whether or not a child has an autism diagnosis or not, that in effect tries to strike down, in my view, the operation of the Disability Act. We cannot properly assess children. We cannot finalize those assessments unless we have those children assessed. And the distinction between assessment and service is important. So I would say watch this space in relation to that new procedure, which in my view has a lot of legal holes in it. It's also important to bear in mind that for many people, access to the assessments themselves, as difficult as they are not the end of the story. What we want to see is early assessment, because when we want early intervention. Professor Rita Honan, who may be known to a lot of you, who's a world-renowned expert on autism and hails from Ireland, did a really, really significant affidavit in a High Court case about 2 years ago, where she set out in very plain terms the importance of early assessment and the importance of early intervention. And where we don't have early assessment and early intervention, the long-term difficulties in terms of accessing a whole range of supports, where that leaves us. And therefore, all of the Superior Court judgments in this whole area do lay great emphasis on the need for early identification in the hope and expectation that early intervention can then be targeted. And we have seen great progress in terms of progressing service provision in a range of cases. Assessments of need must be reviewed within the time frame which is set down by the assessment of need process. Assessments of need must be multidisciplinary in nature. Assessments of need where a disability is diagnosed must lead within 30 days to the delivery of parents of a lawful statement of services. Those services must set out the commencement date for those services, the review date, what services are going to be offered and by whom. And again, we need to ensure that those service statements are consistent with the lawful requirements. So there is a lot more accountability now, there's a lot more thought, and there are a lot more opportunities for parents and children now to access services. And if we lead then into a schooling type situation, of course we know that these assessments and these services are hugely important, not just in terms of the private or indeed public services that parents have to acquire, but also in order to access the curriculum effectively in school, we need to know what the diagnosis is. We need to know what the pathway for services is. And in that context then, what type of educational environment is appropriate and what type of services are appropriate and what type of supports schools are in a position to offer. And there was a very interesting case called SOC and the Minister for Education and others. And this was a judgment of Mr. Justice Peart then in the High Court. And I'm going to give you the citation because although it's a hugely lengthy judgment, it was delivered as far back as the 16th of May 2007. And the record number of it, or the citation of it, is 2007//IEHC. And it is at page 170 of that text. And this was a civil action which was around what the obligations on the state were in terms of school placements and the provision of education. And it also dealt with late diagnosis and late assessments. And what Mr. Justice Peart said in that particular case, which ran on for a considerable period of time, is that there is an obligation on the state to provide for an education. That is a constitutionally protected right for children. It is not the state's obligation to provide the education itself, of course, because they devolve that to schools and school boards of management. And the Minister for Education does not run the schools. But in law, there must be the provision of education by the state. And so long as provision is made by the minister for appropriate education, then that constitutional duty is discharged. And really then what we are into is what constitutes appropriate education. And that is why then we come back to the point of why it is important that in looking at what an appropriate education is, we need to look at the individual needs of that child. And whether that is in mainstream education environment with appropriate supports, whether it's resource hours, whether it's assistive technology, whether it's an individual education plan that involves sensory movement breaks or time out of the classroom, or provision of special needs assistance, the great heroes of our educational system being the special needs assistant. Whether it requires further assistance in terms of assistive technology grants, Irish language exemptions, for those young people in exam times, exam accommodations, added time, a scribe, a reader, extra time, perhaps in a different venue to others. All of these things are really, really important. And in terms of that assessment of services, here's what Mr. Justice Peart said. He said that 4 months for the diagnosis of a child in the context of the life of a 2-year-old is a very long period of time, 4 months. And he said that in the context of early intervention, valuable time was being wasted. And he found that in fact, as a result of the late diagnosis of this particular child, that was negligence. It wasn't a breach of statutory duty, it was a classic case of negligence. And what he said was that at the time at which the GP referred that child to the Lucina clinic for diagnosis, that the duty of care on the HSC arose at that point. And that's when the time started ticking. And there was a 7-month delay in relation to the diagnosis of this child, which he considered to be unreasonable and negligent. And arising out of that, he awarded damages to that child in the sum of €50,000. That is a case which dates back, as I say, to 2007. The other thing is that as an alternative to that, the Department of Education through the National Council for Special Education and their network of CNOs, who are there to assist parents in enrolling children in schools. They also collectively provide an alternative to school where perhaps school is not a school placement or an appropriate school placement is not available. And that can often take the form of home tuition. Home tuition is seen as a short-term compensatory measure. That's the phrase that is used. And there is a case called A. McD, and this is a case from 2012. And Miss Justice Isolde O'Malley, who's now in the Supreme Court, in 2013 said the following: "On the balance of probabilities, home tuition, even with the best of tutors, is not designed to replace the form of social education gained by learning how to get along with one's peers and other people. If this is not remedied, her future life will be difficult in the extreme." For many families that come to me and come to Julie and her colleagues in the Children's Rights Alliance, they are often left for quite considerable periods of time with no school placement, or in the alternative, home tuition. Home tuition is a short-term gap. It is not a long-term solution. And we all know that the definition of education goes far beyond whether or not we can speak Mandarin by the age of 7, or do algebra and very extravagant equations by the age of 3.5 or whatever it is. The definition of education includes social integration, the ability for structure and routine within the school and working and learning environment. And home tuition as a long-term solution does not meet that obligation. There are some interesting circulars on the Department of Educational website which do talk about different types of home tuition. There are arrangements for the continuation of home tuition by distance learning for the duration of the pandemic emergency. And there are 3 different categories of home tuition. One is where there is home tuition for children with special educational needs and medical grounds. That is for children perhaps who have a chronic illness who are unable to attend school, and provision is made in that regard. Secondly, there are home tuition for reasons other than special educational needs and medical grounds. And that might be, for example, where somebody is temporarily without a school place, or without the offer of a school place, or for where a school is being actively sought, or for example, perhaps where a child has been excluded from school. And then a final category, which perhaps is not used as often, but it does exist, is home tuition for students who are on maternity related absences. And that is also a scheme that's available. I'm not sure what the figures are in relation to that. A lot of parents come to me also and they say, I've had to sign this consent form for a reduced school timetable. And the question is, how lawful are those? Well, for some parents, of course, if a child can achieve an hour and a half, 2 hours a day, that is a welcome development. And that is perhaps, from their perspective, at that particular time, all that that child can perhaps manage. Again, perhaps a short-term measure. Again, to be looked at in the context of an overall plan. Where it gets difficult is where parents are being asked to sign a consent form for prolonged periods of reduced timetables. And the question is, does that vindicate a constitutional right to a child? Does that enable them that approach to access the curriculum? For what purpose is the reduced school timetable? And these are all questions which have to be looked at in terms of meeting that constitutional right to a child. And very sadly, and I think Julie's probably in the same boat, we are seeing an overuse of reduced school timetables. We are seeing an increasing use of it since the return to school in September, some for very valid reasons, some for very questionable reasons. I know that we have raised this at our Oireachtas level. I know that the previous Minister for Education in the Dáil has referred to reduced school timetables as a temporary form of suspension in some circumstances. And therefore, just as you can apply and make an appeal under Section 29, so-called Section 29 appeals, all again on the Department of Education website, just as you can do that for failure to enrol, just as you can do that for suspension, just as you can do that for permanent expulsion or exclusion, so you can also do it for reduced school timetables. The prolonged use of that should enable parents to take a Section 29 appeal in that regard. Finally, in the last 5 minutes or so, I want to just talk a little bit about perhaps the approach of parents to trying to navigate these difficult, as I always call it, the 110-meter hurdles, where you are expected to jump a number of hurdles, and then when you finish the race, you suddenly look ahead and the 110-meter hurdles are actually being set up again on the other side of the track. And that's no way in which to bring up a child. it is no way in which to be a child in this system. We went in 2012 to the people of Ireland, asking them to protect and to vindicate the rights of children in a children's referendum, to give children a voice, to protect children, and to give children rights as rights holders in their own right, and not some sort of add-on to the individual rights of their parents. We must look at this as from a children's rights perspective. We need to look at the long-term cost to our society if we don't get this right, if we don't get early intervention right. There's a human cost, there's a financial cost, there is an emotional cost, there is real cost to family life. And it behoves all of us then, policymakers, advocates, parents, schools, multidisciplinary teams, to look at what is in the best interests of that child. How can we design a system where in fact we are looking at the individual considerations rather than expecting children to fit within a system where mental health services and disability services fall out with one another over which budget something comes out of, where government departments often don't speak to each other or collaborate with each other in relation to the delivery of rights for children. We've got to get away from that. In terms of final do's and don'ts, it's very important that we remain on the pitch of play. It's very important that we engage. It's very important that we, as parents and advocates, at times need to take a deep breath, to look after ourselves, to look after our own welfare and our own mental well-being, because the stronger that we are, then the stronger that we can be as advocates for children. Let's never forget that there is no greater advocate in the life of a child than their own parents and carers. There is no greater support to a child than their own parent or carers. And there is no greater expert in a child's life than their own parent or carer. And it's really important to bear that in mind. It's also really important to bear in mind that there is an increasing realization by the courts that the disrespect for a parent's input is no longer as clear-cut as it used to be. Whether it's in words of court situations. I was on a webinar yesterday looking at vulnerable adult legislation with the Law Reform Commission. And one of the themes that emerged from that was how parents of young adults with disabilities or with a diagnosis feel very disempowered by public bodies who try in some ways to bypass parents at the age of 18, citing all sorts of things like, well, they're an adult now and their GDPR issues and so on. There has never been, probably in the history of our country, a more misapplied, abused concept than GDPR and privacy grounds and freedom of information. And so it's very, very important that when we're all here together, that we know our rights, that we know that we probably have much more rights than we think we have. And we certainly have a lot more rights than we're led to believe by public authorities that we have. My final point in relation to that is quite often parents want to try and see whether or not they can apply for an assessment of need, for domiciliary care allowance, for added supports, whether it's an Irish language exemption, whether it's accommodations in schools, whether it's the parking permit that enables you to go out in public with your child who has a disability. And quite often what they say is that they speak to people about this and they say, oh, don't apply for that, you're not going to get the criteria, you're not going to meet the criteria for that. All I will say to people is, in the final analysis, if you don't apply for things, there is one guarantee, you won't get it. And your legal rights and your advocacy rights are only engaged when you apply. And I have lost count of the number of successful cases that we've been involved in, where it started off with the parents saying, I was told that if I applied for this, I wouldn't get it. It is only by getting it that your legal rights are engaged, that we're able to look at the criteria, that we're able to look at reviews, appeal systems, oral hearings, the list is endless. So as I say, and I say at all of these types of events, you have way more rights than you think you have, and you have a lot more rights than you're led to believe you have. So there are three alwayses, if that is a term. Always engage, always apply and always stick in there and stick at it. So thank you very much indeed for your attendance in such numbers tonight. It feels really weird. I think I probably do speak for Julie and I when I say this is just a very surreal experience. But it's really good. And I guess for many people, so many of these things are Dublin centric. I know that I did a carers roadshow that took me all around Ireland in 2019, and it was just the most amazing year of getting into places from Donegal down to Wexford and across again. But for people who can't always travel to Dublin or to the big urban centres where we tend to hold these things, this is an amazing opportunity to engage, albeit as strange as it is. So thank you again to AsIAm. I'm looking forward to hearing now what Julie has to say. The Children's Rights Alliance I have an amazing array of people and an amazing vision for creating that type of society in which we as parents and as carers and as advocates are trying to create the type of Ireland in which it is the best country in the world in which to be a child and to care for a child. And they are a leading light in that effort, and I thank them for everything that they do. I better say something finally about AsIAm as well, just to ensure that Nicola and her colleagues don't feel left out. But again, the power in awareness, the power in raising profile, and all of the amazing projects that are being done by all of you at AsIAm continues to inspire, and I wish you well as we continue this journey together. So thank you very much indeed.
Thanks, Gareth. Really appreciate that. A lot of questions coming in the inbox as well. Hopefully we'll be able to answer some of them at the end. So I'm just going to pass you over to Julie now. Julie, you have a presentation, isn't that right?
I do indeed. We're doing a lot of these now in the Children's Rights Alliance at the moment, so we've become very, very aware of how to work online, even though, like Gareth, naturally this isn't my forte either, but I've gotten used to it. So thank you very much to having me here today, and it feels weird saying that to you coming from my own house, but it is great to be here with AsIAm. I was delighted when the community engagement team asked us to speak to AsIAm, because AsIAm are one of our most active members at the moment in terms of engaging with the Children's Rights Alliance and the issues coming up for children, particularly with additional needs and with autism. And really, I suppose what I'm going to do here today is I'm just going to introduce you to the Children's Rights Alliance, talk to you a bit about the work that we do in trying to make sure children are put front and centre in government policy, legislation, services. And then I'm going to talk to you about specific things that we have in the Children's Rights Alliance that might be of use to you as parents, as advocates, or even if there's any children or young people here themselves. And they are a Know Your Rights guide and our legal information and advice services. So I'm just going to kick off there now, and hopefully this works. Yes. So by way of introduction, the Children's Rights Alliance is an umbrella-based body. We have over 120 members across Ireland who are work together, and as Gareth said, to make Ireland one of the best places in the world to be a child. That is our vision, and it has been for the past 22 years, I think now we're in operation. Our members come from all over the country. We have a wide variety of members coming from every area of children's lives. So we have community-based organisations in rural Ireland. We have large national children's organisations like the ISPCC and Bernardo's. We have organisations focusing on specific issues like AsIAm, like Pavy Point. And then we also have organisations whose primary work might not necessarily be with children or young people, like the Irish Heart Foundation, who would have a stream of work that they do and want to get involved in making their work come from a more children's rights approach. And power in having an alliance like the Children's Rights Alliance is that we can work with our members to find out what are the issues on the ground, what are the solutions, and we can work with them to develop the solutions. And then the Alliance and its members advocates to government to change laws, to change policies, to change services, and really put pressure on government to put children first. So we look at what are the issues that are coming up, systemic issues is what we call them, the issues that are coming up time and time again. And we try to raise these through the different channels that we have to try and make change. So what I'm going to do is I'm going to talk to you about an example of some of the legal and policy work that we do, just so you can get a flavour of what happens in the Children's Rights Alliance. So I've a list of a couple of different bits and pieces there. I'm going to touch on Know Your Rights a little bit later. That's a very specific piece of work that I think would be of very big interest to this audience. But what we try to do is we try to hold government to account when it comes to children. And our flagship tool for this is our report card. And our report card is it's where the Alliance takes what the government promises for children in the programme for government, and it grades them on how they have achieved this. And this is a really important tool for us to really hold government to account. And we find it is very effective, because effectively they have made the promise and we're telling them how good they've done in implementing it and making a difference in the lives of children and young people. And previous report card commitments in the area of children with additional needs have focused on children who need special educational provision, and they focused on other issues around health provision in previous years. And we're really excited about the new programme for government, because we have done a lot of advocacy and a lot of lobbying to get some good commitments in there for children and young people with additional needs that we will now be tracking. And two of them are reduced timetables, which Gareth was speaking about there earlier. And we're really excited to have the opportunity to track the use of reduced timetables and the government's efforts to have them only used in appropriate circumstances. So this will be a tool for the Alliance to go out to the members to get information from the ground about what they're seeing. So I know AsIAm are working a lot on this issue, and they've been feeding in a lot to our report card this year already about the issues they're seeing in the use of reduced timetables. And then we also engage with government departments and agencies. So they would provide us with information and with some statistics in terms of what they're doing to realise this commitment and to make sure that this is only used in appropriate circumstances. And then we would advocate with them with solutions, with recommendations of how they can make this real and change the lives of children and young people. And another really important commitment in the programme for government that we are going to be tracking is a commitment around making sure all children have access to an appropriate school place in line with their constitutional right. And this again goes back to what Gareth was saying that he is seeing in his work, and what the Alliance sees a lot in our work and through our members. And we're going to have the opportunity through a report card to track for the next 5 years, or however long this government is in place, how they manage to implement that commitment. And we find, as I said, it's a really effective tool, because effectively the government have promised this themselves. So it's us telling them how well they're doing in terms of their own promises. So that's one of the tools in which we use to try change laws, to try to change policies, to try change services. Other tools that we use are the UN Convention on the Rights of the Child. And this is a large convention of children's legal rights and entitlements across a wide range of areas, including disability, including education, including access to health services. And what we do in this process is the UN Committee on the Rights of the Child reviews Ireland, and that is how they monitor how Ireland is doing. And in the review process, we are able to raise issues, trends that are happening on the ground that our members bring to us, and we're able to advocate for the Committee on the Rights of the Child, which is a UN body, to give Ireland specific recommendations for change, which the Alliance then uses in our day-to-day work to try to get government to change practices, policies, procedures here in Ireland. And what we found is this is a really effective mechanism for creating change, because there are some issues that time and time again, year after year, they are never changed in Ireland because they mightn't be something that is attractive to government. And this process can help us to change these issues. So one of the big things that have come out of this process previously have been things like the recommendation around having an ombudsman for children, which was introduced following our first examination, or the ending of holding children in adult prisons, which is introduced after a second examination. And in the next year, we're going to be going into our sixth examination. And it's really important this time around that we look at what the key systemic issues are, and we rely on our members to bring these to us. So AsIAm are very, very engaged in terms of bringing issues to the Children's Rights Alliance, and we'd hope to be able to make some big changes in terms of systematic issues for children and young people with additional needs. So then I'm just going to speak briefly in terms of the training of professionals. So the Alliance engages in training with different types of professionals, and Gareth has been involved in helping us with this before in specific training around mental health. And we are currently engaging with training with social care professionals and professionals within TUSLA and with legal professionals. And what this does is try to upskill them in terms of what children's rights are in specific areas, so that all of the focus is not on parents, on guardians as carers as being the sole advocates, but trying to make the professionals who work with you and upskill them in their knowledge that they too can become advocates for your children and young people that you have in your care. So I'm just going to move on there now to our Know Your Rights Guide. So Gareth mentioned the children's referendum in 2012. And the Children's Rights Alliance, along with the ISPCC and Bernardo's, engaged in a large nationwide campaign to try get a yes vote in the referendum. And I remember myself, I was part of the campaign. I was on a campaign bus that went around the south and east of the country with giant pencils and multicolored balloons, and it was a fantastic time. But what we learned during that campaign actually was that knowledge of children's rights is really low in Ireland. And as Gareth mentioned, you have way more rights than what you realise, and way more rights than what you're led to believe you have. And what we found at this time is that parents, children and young people themselves, as well as just the general public, had a really low awareness of the amount of rights children and young people already have in Irish law. So because of this, we reflected in the Alliance how we can have a role in trying to increase the knowledge and the use of children's rights. And through that, we created our Know Your Rights Guide. And this week, we've actually launched a second one, specifically on online privacy and safety. So the Know Your Rights Guide is a plain English guide on children's legal rights and entitlements. And it goes throughout every area of a child's life. The right to be treated equally, the right to education, protection from harm, up to the right to shelter. And most importantly, it is written for a young person to understand. What that means is that it's very understandable for all adults, because there's so many different sources of rights, there's so many different laws, there's so many different policies, that this is just one-stop guide. Now, with a hazard warning, if you were to print off the whole thing from start to finish, it is about 300 pages, but it is designed that you can go into, and what I'll do is I'll put the link to the guide into the chat when I'm finished, but it's designed that you can click into your area. So if it was education, you go into education, and if your question was around what to do if my child gets suspended, you flick through the questions till you find your question, and what you need is there. And really importantly, when we were designing the guide, we did consultations with not only our members, but with expert lawyers, with government departments, and really importantly, with children and young people themselves, to make sure that the information was, first of all, correct and accurate. Second of all, that it was meeting the needs of everyone who would be using it. And the consultations with children and young people, I had the joy of doing them down in Cork. I'm from Cork myself, so any excuse to get on the road, and went down to Cork and had 2 different consultations with young people. And they were really, really instrumental in making sure that the information in there was correct in terms of what children and young people wanted, but also that it was written in a way that made it more accessible. So for example, in my right to be treated equally, there's a fantastic table of what age can I do different things. And in that table, one of the young people said, well, you're missing one key piece here. Right? And I was saying, well, what am I missing? Well, I want to know what age I can get a pilot's license. So that was put into the table. When it came to the protection from harm chapter, the young people thought that it was actually written quite coldly and quite legalistically. So we had to change the wording and try to make it more accessible. So it's a really good guide for people as that first step of, you know, when you're thinking, God, is there anything I can do in this situation? It's a first stop shop for you as a parent, guardian, carer, or even for the children or young people in your lives to have a quick look and say, okay, I do have rights in this situation. What are they? And from there, it also directs you to where you can go to get more information and where you can go to get help. And not just information in terms of taking action, but also that piece that Gareth mentioned, the people who are trying to fight constantly for the rights of their children can often, you know, need to look after themselves and to mind themselves in the process as well, because it is exhausting to constantly be in battle. And the guide points resources to where you can go as a parent, or if you have a young person who you think needs a bit of extra support or help, a wide range of different resources. And the Where I Can Go to Help section at the back has a couple of 100 different organizations, places you can go for all different aspects of what you might need, be it some information, be it peer support, be it community support, anything you can think of, it's pretty much in there. And just so you know what it looks like, I have my right to be treated equally. So you can see there, this is the first start of the guide. Each section has its own cover, so you can see what it is, but then it's in questions and answers format there in front of you. So you can see how it's written, and it's written, and NALA have proofed it as plain English, so it should be very accessible. So sometimes what you might find is that as a parent or advocate, just knowing the general information isn't enough, that you actually need to contact someone to either figure out, well, actually, is that what applies to my situation? Or to find out, okay, my situation is quite complex, or I'm not sure what this means. And because of that, the Children's Rights Alliance in 2018 set up a free children's rights helpline. So this is an information line where you can give us a ring. We are open Mondays and Wednesdays, and actually since COVID-19, we've opened on a Friday morning as well, because we've had an increased demand. And on this phone line, you can give us a ring, and we will be able to talk you through what you can do in your situation. We have the line open for parents, for children, for young people, for other family members who might want some information. So sometimes we get calls from, maybe a grandparent who just wants to have a bit of information that they can help support the primary caregiver, the parent in any situation. And then we also get phone calls from people who work with children. So we often get a lot of calls from family support workers who are interested in figuring out, well, they have a family in front of them who need to access a service. How can they help them in that battle? And what we do is we give you the information, and we also try to provide you, like I said, with contact with some sort of other service if necessary. So, if a parent is needing a bit of parental support or some help or guidance around that, or if a child is ringing us and they actually need someone to talk to as well, not just the information about their rights, but actually just some information about how to mind themselves and trying to fight for their rights, we give them that link in as well. And we also operate by email, because sometimes we find that, particularly for parents who've been battling on through things for a long time, it's hard to say everything over the phone and to make sure you remember everything. And sometimes time can be tight, so you can just pop us an email at any point and we get back to people within a couple of days normally. And then the next level is sometimes people may need to go and get some legal advice, or may need to talk through with someone how they might go through some sort of a process. So like Gareth mentioned, there's a process on the Department of Education's website called a Section 29 process around suspensions, and we get an awful lot of people coming to us around suspensions. And sometimes what we try to, if over the phone is not enough, we would offer them a legal advice clinic appointment, where they'd have access to a free initial appointment with a lawyer, a specialist in the area, who would give information and advice in that session to the parent about how they might go through the process. So it is a one-off appointment in terms of supporting families to empower them with the knowledge and rights that they need to know in order to continue their battle to get what their child needs. And just to give you a flavour of what came up, so last year the 3 top issues that we got from parents who were in contact with us on our phone line were around education, family law and children's rights. And in education, what we've seen quite a bit of, as I said, is in relation to suspension, expulsion, but also in relation to accessing appropriate school places. So what we find is that a lot of parents struggle to access an appropriate school place for their child, particularly children with additional needs. And we're able to give them information about what their options are and what their rights are. Because like Gareth said, you've far more rights than what you realise and what you're led to believe. So you can give us a call and we can give information on that. And then family law, then we get a lot of calls from parents in family law matters. And then children's rights is almost like a catch-all for everything else that comes up that might not fit in. So we take calls on absolutely every aspect of children's lives. So sometimes we can get things that might not go anywhere else. Then the top issues we get from children, so we receive calls directly from children and young people themselves. The top issues for children last year were around children's rights. So a lot of those are children asking what age they can do different things, what age they can consent to medical treatment, what age they can get a tattoo. What I get an awful lot of is what age can I babysit? And then one that I'm getting more and more as time goes on is, can I hold a protest? So children, young people who might want to hold a protest. Then we get an awful lot of calls from children around immigration and also around family law. And then COVID-19 has brought up a lot, well, it's brought up some new issues, but actually it's highlighted some issues that this year are really, I suppose, coming up a lot more for families, particularly families for children with additional needs. And more we're seeing that it's actually pushing families more with COVID. So families who would have already been fighting every year to access appropriate school places, health supports, or facing what we're seeing particularly as a reduction in school supports, because we're finding that a lot of special educational needs teachers and assistants are actually being used to cover COVID work, such as maybe covering the door for all the different classes, or maybe have to cover more yard duties, or being roped in to cover classes if teachers are out sick. So we're finding that a lot of issues that would have come up in the normal course of our phone line or clinics are coming up more and more this year since the schools reopened for children with additional needs. And one of the big ones that we're seeing is that issue of reduced timetables. And we're hoping as the Alliance to do a lot of work in this area next year in terms of trying to engage with government around the issues that are coming up in this. We've seen, you know, children as young as 5 being put on reduced timetables as they're first starting school. And as Gareth mentioned, sometimes they are very welcome to parents and they're very appropriate for children and young people because it's in their best interests. But I suppose where it becomes a problem is where it's for a prolonged period of time, but also where it's not in the best interest of the child. So for some children, it is the best way to get them into school is to start on a reduced timetable and gradually increase it. But we see some children, and not just children with additional needs, but what we see increasingly is, you know, children who might be from an immigrant background or traveller children also being placed on reduced timetables. And that is an area that the Alliance is really concerned about, because one of the most fundamental rights of children in Ireland is their right to education. And to have that interfered with in a way that isn't in their best interests is really of concern to us. So it's something that we're going to be looking at working on next year, and we're going to tie in closely with AsIAm. So that is just an overview of the Alliance, some of the services we have and some of the issues we work on. And just to say thank you so much for having me here today. As Gareth mentioned, it is an odd way to be at one of these events. Normally you can have a chat with people and talk through things a bit more, but I'm absolutely delighted to be here, and thank you so much for listening to me.
Thank you so much, Julie. Really appreciate that. Great, so we have about 10 or 15 minutes just to go through a question. There's a lots of questions there, so I've just flagged a couple for you guys. The first question is about assessment of need, excuse me. So there's like two kind of in a row here that are quite similar, so I'm just going to read them out together. So they're just asking what constitutes the start of an assessment, so questions over the phone or the first contact with the child themselves. Another one says, is it the time of the GP letter, psychology letter? I have many students who are waiting a lot longer than 3 months for an assessment. So does anyone want to answer that one?
Yeah, well, when you apply for an assessment of need under the Disability Act, you get an acknowledgement letter from the HSE. So that's the time starting. It must be commenced within 3 months and then must be completed no later than 3 months from the date of its commencement. Quite often, in practical terms, the first contact will be somebody who will send you out a questionnaire. So that is the commencement of it. And that sets in train then the statutory timeframes permitted by law. So yeah, so that's how those are the timelines. I agree with your questioner, and I think I did say at the start, there are probably more assessments not being commenced and completed in time in various parts of the country than there are commenced and completed within the timeframes. And we've seen from Justice Peart's decision way back in 2007 and some other decisions since then, how the courts treat that simply as negligence. And in fact, the courts had looked at it from the date of the referral back in 2007, or before that, sorry, would have been prior to the enactment of the Disability Act of 2005. I have seen just some of the other kind of questions as well that have come in, and people say, well, look, what can I do about it if this happens to me, or if I don't get services, or if my assessment of need is not reviewed in time, and various things. There is a complaints procedure there, and I think I must have sent out about 20 complaints in the last week, so I'm kind of familiar with this area. And what happens is we in fact give the complaints officer a proposed timeline for the resolution of this issue. And what the Disability Act says is that if the assessment of need officer, if the complaints officer, comes back and upholds your complaint and makes recommendations, if the HSE don't honour those recommendations within a period of 3 months from the date of that complaint being determined, then you have the right to go into the circuit court and have that determination enforced. And so we've seen a huge number of circuit court cases where in fact the courts then make orders in respect of the assessments, in respect of reviews, in respect of services themselves. And so what I'm saying is that the window of opportunity has now opened greatly in terms of having these things legally enforced. And it often makes me both confused and despairing, the fact that it actually takes a legal action to have to actually vindicate your basic rights. Because bearing in mind that you will all get letters saying, oh, we can't do this because we don't have the psychologist in post, or we don't have X, Y, and Z. That, with the greatest of respect, is not the problem of parents. It is not the problem of children. And that goes way beyond their areas of competence and responsibility. The Act makes it really clear. Lack of resources is not the basis of not completing these assessments. And any letters that come in that say, well, we can't do this and you're now on a time, our timeline will be 2 years away. Those are unlawful letters, and they're never relied upon when court actions are taken. They never come in and say, oh, well, here we're saying that this is going to take 2 years. The final thing before I go back to you, Nicola, as well, is that I was kind of just screening some of the questions there, and a big issue comes up about this new standard operating procedure. Again, in my view, the assessments that are going to be completed are proposed to be completed under that protocol was opposed by the representative bodies. It was opposed by the Psychological Society of Ireland. It was opposed by the speech and language therapists. It was opposed by all of the professionals that deal with children. That's the first point. The second point is that how can you say that you have determined whether or not a child has a diagnosis and the extent of that diagnosis if you don't do the assessment for the diagnosis? There haven't been any legal cases in respect of this yet, because it has just rolled out, and obviously it rolled out, I think, in January, and then you have your 3 months and your 3 months and then your 3 months before you can actually go down the court route. So very, very soon this is going to be challenged, and it's going to be very interesting to see what occurs. I'll say no more than that.
Just following on kind of the same topic, we have a question here. My son's in 5th class. He has had one assessment of need. Does he need to get another one before he goes to secondary school?
The new model in relation to educational provision, and we're moving away, thankfully, from a model that is assessment based to one in which it should be based on need, although quite often it's difficult to know how you know what a child's needs are unless you've assessed them properly, but that's a separate argument. What I would say to you is that within the assessment of need report that you get back at the end of this process, included in it is this assessment is to be reviewed on X date, quite often maybe a year or 2 years after. And why is that review important? Well, children's needs change. What might have been there as a 5-year-old, is not there at 7, and vice versa in terms of need. And quite often as well, particularly with younger children, the clinicians will come back and say, well, look, those results should be treated with caution. We should look at this again in 2 or 3 years' time, etc., etc., etc. So within the body of the assessment itself, it is important to see whether or not the professionals themselves are saying, look, these assessments should be redone at a future point. But aside from that, every single assessment of need has, this is to be reviewed on X date. You will not get a phone call on that date from the assessment of need officer saying, we are going to be reviewing you now. It has never happened. And so the onus is placed on parents and carers to go back to the assessment of need officer and say, this is to be reviewed. A service statement then will be revised. And in fact, here are further assessments that we think or has been recommended to us should be done, whether it's by school, whether it's by private clinicians or whatever the case may be. So there are always opportunities for review, and rightly so, because as I say, children's needs change. And what might have been needed for the child in terms of physiotherapy and the gross motor skills and so on, it might have resolved itself. They may need psychology, however, at a particular point. They may need other services and supports. So there should be sufficient flexibility within the system, and it is what the Disability Act envisages. So the answer is that there isn't a set time frame for the answer to the question about should I go back at primary school. Within your own service statement itself and within your own assessment, it should be done. The final thing, that I should say is that some people are asking about, should there be a timeline for the services? That's a really good question, and one that loads of parents ask. Within the service statement itself, it says it must give you a commencement date. Now, lots of parents that I deal with will say, well, wait a second, I've just been given a service statement to start in August 2022. And yet the assessment of need report will say they need psychology urgently, or immediate intervention is needed for OT, or immediate intervention is needed in that. If that's not reflected in the service statement, that can form the basis of a complaint. And if the complaint can be determined in a way that actually holds to the core of what your assessment of need assessors say, i.e. this is needed immediately, urgently, as soon as possible, that forms the basis then of your legal argument later on down the line that the services are not being delivered in line with your child's assessed needs. So I'm feeling increasingly optimistic that we are beginning to break through the bubble of can't do, won't do, and you'll wait like everybody else. That's not child-centred, it's not child-focused, and it's not what the Oireachtas, from my reading of the Act, intended in the Disability Act.
Thank you for that, Gareth. I just have a question for Julie here. Is there anything down the pipeline, like a children's rights guide for teachers and early years practitioners? I think it's something really topical for children to know their rights. We visited the Ombudsman office last year in Dublin on a field trip, and it drummed up a lot of interest.
Yeah, the Ombudsman's office, if anyone hasn't been there.
I've been there too, it's great. It's
great
so fun.
Place to go. And I know that like loads of children, young people go there. They're actually doing, with COVID-19, they're actually doing things online. And so they'll take schools and schools through Zoom. At the moment, we don't have any guide in the pipeline for teachers, but now that it's been suggested, we could very well do when I get back to the office. No, I think that's, I mean, a lot of the calls we get actually are from teachers who are as concerned as parents about what's happening for their children that they're looking after, and they want to advocate. So, I mean, it would make great sense for us to do some work specifically with teachers, and we do have all of the teachers' unions within our membership. So trying to utilise that, I think, is something, it's a great idea. I actually hadn't thought of it. And in terms of early years, we actually work with the early years members in terms of doing some consultations with children and young people who are in their early years. So we've done consultations with children as young as 6. But in terms of a guide, we haven't thought, as young as from 3 to 6, apologies, the young as 3. We haven't thought of doing a guide, but it is a very good idea in terms of trying to engage them in their rights. So plenty of food for thought for me coming out of this.
Great. Sorry, there's so many questions. I'm just trying to like filter through them. So sorry if we can't get to them this evening. There's a question about home tuition that I flagged earlier as well. It says, is there any law whereby we could get home tuition granted retrospectively for all the months lost in the process, and families should have flexibility to engage a tutor to catch up on the missed time? Do anyone know anything about that? Like, is there like an opportunity to, basically make up for lost time if you have lost time in school through home tuition?
I'm of the view that there's absolutely nothing, first of all, that prevents that. I think it will depend, obviously, on the individual circumstances of the case. I think you have to demonstrate, obviously, where the prejudice and the loss of opportunity has arisen. But I've been involved in lots of cases where we've settled on the basis of giving additional input in order to try, and I use the word try, and mitigate and alleviate the loss that's already occurred. So yes is the answer. There's no reason why if a state body has done something that in terms of resolving and restoring the right, that shouldn't be done with additional supports and enhanced levels of service. And I think it's a really good question, and the answer to that is I can't see why not. I don't know if Julie thinks the same.
Yeah, and I've actually seen, like Gareth, families who have managed to secure it, but again, it's about trying to make sure that you document and try to capture that learning. But yeah, no, there's absolutely nothing stopping people, and people have managed to do it with and without going to court, actually. So it is definitely one to consider.
I mean, Nicola, one of the things that I should stress to everybody, and I know I come at this from a legal background, 99% of cases that we're involved in never come to court. They're always just dealt with by way of informal advice, by support for a teacher, and an awful lot of, a lot of the queries that I would get would come directly from an SNA or a teacher themselves. And, you know, I know there was talk about the guide, which I think is a brilliant idea in terms of teachers and SNAs, because I would get a lot of school principals and teachers who come to me and say, I really need this additional support. How do I go about getting it, etc. So I think there is a thirst for knowledge and information out there. So I would be really supportive of the idea. I think Julie will have to try and secure the funding for that project.
We're roping you in yet, Gareth, have you?
But yes, look, there's a temptation to think that we all have to run to court about everything. And as I said, 99% of these things can be dealt with by way of a letter, by way of everything else. And can I tell you this? State bodies do not like precedents which go against them, because it means then, from their perspective, that this floodgates argument arises. And I've been involved in so many cases where, very quietly, we have in fact achieved much more out of court than we might have achieved in court. And I think that's also really, really important to bear in mind.
Perfect. I think that's all the time we have for questions, unfortunately. A massive thank you to you both. We really appreciate you both giving your time to be with us this evening. I certainly learned a lot from both conversations, so thanks very much. And I'm sure everyone who tuned in learned a lot too. Just a reminder that this will be available on YouTube from tomorrow. So if you want to share with any friends or colleagues, please feel free to do so. And I'm so sorry if we didn't get a chance to answer your questions, but if you do have any questions, please email into info@AsIAm and we'll do our best to answer them. We just wanted you to know as well, we're part of this webinar series. There's going to be another webinar in December, on the 9th of December at 7 p.m. and that's going to discuss adult diagnosis and how to get one, and we have some great speakers from them too. More information about that on our social media next week. But thanks again so much, guys, for joining us and speaking to us all and sharing your knowledge with us. And thanks a million for everyone for joining in for tonight. It was a huge outcome. It's brilliant to see everyone here. Thanks a million, guys.
Thank you.
Thank you.
Thank you. Bye, guys. Take care. Bye-bye.